ट्रांसफर ऑफ जजेस देखते हैं तो प्रेसिडेंट कैन ट्रांसफर अ जज फ्रॉम वन हाई कोर्ट टू अनदर after consulting the Chief Justice of India. On transfer, he is entitled to receive an additional and in addition to his salary such compensatory allowances as may be determined by the parliament. कौन determine करेगा? Parliament. In 1977, the Supreme Court ruled that the transfer of High Court judges could be resorted to not only as an exceptional measure and only in the public interest and not by way of punishment. Again, in 1994, the Supreme Court held that a judicial review is necessary to check arbitrariness in transfer of judges, but only the judges who is transferred can challenge it. In third judge's case, 1998, the Supreme Court opined that in case of the transfer of High Court judges, the Chief Justice of India should consult in addition to collegium of four senior most judges of Supreme Court, Chief Justice of two High Court, one from which the judge is being transferred and other receiving him. तो यहाँ से क्वेश्चन काफी बार बन चुका है. क्या है आपका थर्ड जजेस केस 1998 सुप्रीम कोर्ट ओपाइन दैट इन केस ऑफ ट्रांसफर ऑफ हाई कोर्ट जजेस, यानी कि अगर इस हाई कोर्ट से इस हाई कोर्ट अगर जज को ट्रांसफर किया जा रहा है तो चीफ जस्टिस ऑफ इंडिया शुड कंसल्ट, तो सीजीआई इंडिया शुड कंसल्ट इन एडिशन टू कॉलेजियम ऑफ फोर सीनियर मोस्ट जजेस ऑफ सुप्रीम कोर्ट. फोर सीनियर मोस्ट जजेस यहाँ आपके हो गए सुप्रीम कोर्ट के कॉलेजियम, चीफ जस्टिस ऑफ टू हाई कोर्ट, अब आ गए आपके चीफ जस्टिस ऑफ टू हाई कोर्ट सीजीआई दिस एंड वन फ्रॉम द जज बीइंग ट्रांसफर्ड, जहां जा रहे हैं वहां आ रहे, ये हो गया. Thus, the sole opinion of the Chief Justice of India does not constitute the consultation process. सिर्फ सीजीआई के भरोसे नहीं हो रहा है, यहाँ भी है और ये कॉलेजियम तो आपका हो गया इंडिया इन एडिशन टू द कॉलेजियम ऑफ फोर सीनियर मोस्ट जजेस ऑफ सुप्रीम कोर्ट. फोर सीनियर मोस्ट जजेस आपके सुप्रीम कोर्ट का और ये दोनों एडिशन के साथ ट्रांसफर होगा. यही क्वेश्चन बनता है. Removal of judges pathway. A judge of High Court can be removed from his office by an order to the President. The President can issue the removal order only after the address by the Parliament has been presented to him in the same session for such removal. The address must be supported by a special majority of each House of Parliament, that is, majority of total membership of that House and majority of not less than two-thirds of the member of that House present and voting. The grounds of removal are to prove misbehavior or incapacity. Thus, a judge of High Court can be removed in the same manner on the same ground as judge of Supreme Court. The Judges Inquiry Act 1968 regulates the procedure relating to the removal of judges of High Court by the process of impeachment. A removal motion signed by 100 members in the case of Lok Sabha or 50 members in case of Rajya Sabha to be given to Speaker and Chairman. The Speaker Chairman may admit the motion to refuse to admit it. If it is admitted, then the Speaker Chairman is to constitute a three-member committee to investigate into the charges. The committee should consist of the Chief Justice or the judges of Supreme Court, the Chief Justice of High Court, and distinguished jurists. If the committee finds the judges to be guilty of misbehavior or suffering from the incapacity, the House can take up the consideration of the motion. So after the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of judges. Finally, the President passes an order removing the judges. From the above, it is clear that the procedure for impeachment of judges of the High Court is the same as that of judges of Supreme Court. It is interesting to note that no judges of High Court has been impeached so far. No qualification, oath and salaries पे आते हैं. Qualification of judges. A person to be appointed as judge of High Court should have the following qualifications. सबसे पहले he should be citizen of India. He should have held a judicial office in the territory of India for 10 years. He should have been an advocate of High Court. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of High Court. Moreover, unlike in the case of the Supreme Court, the Constitution makes no provision for appointment of a distinguished jurist as a judge of High Court. Oath and affirmation. A person appointed as judge of High Court before entering upon his office has to make and subscribe an oath or affirmation before the governor of the state or some person appointed by him for this purpose. In his oath, Judge of High Court swears to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to duly and faithfully and to best of his ability, knowledge and judgment perform the duties of the office without fear and favor, affection or ill will, and to uphold the Constitution and the laws. Salaries and allowances पे आते हैं. The salaries, allowances, privilege, leave and pension of the judges of High Court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. In 2018, the salary of the Chief Justice was increased from 90,000 to 2.50 lakh per month, and that of a judge from 80,000 to 2.25 lakh per month. They are also paid sumptuary allowances and provided with the free accommodation and other facilities like medical, car, telephones, etc. Retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. Oh yeah, there the 99th Constitutional Amendment Act of 2014 and National Judicial Appointment Commission of 2014 has replaced the collegiate system of appointing judges of Supreme Court and High Court with a new body called NJC. However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as NJC Act as unconstitutional void. Since consequently, the earlier collegiate system became operative again. This verdict was delivered by the Supreme Court in the fourth judge's case. The court opined that the new system, that is NJC, would affect the independence of the judiciary. So we will continue another video. Thank you.